And a very warm welcome to our webinar today. We are going to be talking to you about the latest updates in the Mental Capacity Act and Deprivation of Liberty safeguards. My name is Emma Pollard. I'm a senior associate in our healthcare and public law team based in our London office, and I am chairing the session today, which means I get the very exciting job of telling you all about housekeeping. I'm sure this slide will be familiar to quite a few of you, but just by way of reminder, please do note that your microphones are muted and your cameras are automatically switched off. So if you would like to ask a question, please use the ask a question box to do so. This webinar is being recorded, and a copy of the presentation slides can be downloaded from the related content box, but please don't worry, we will also be emailing around a copy of the slides at the end. Your feedback is really important to us, so please do complete our survey at the end of the webinar or click on the orange icon at the bottom of your screen to do so. That does also allow you to tell us about other topics that you would really like to hear from us on. Webinars are very bandwidth intensive, I've been told, so please do close all other browsers and programs that you have, and you can always try pressing F5 to refresh if you have any issues. Please make sure your computer speakers or headset are turned on and the volume is up so you can hear us, the presenters. I think it's also worth saying that if you are having any technical difficulties, the best thing to do first is to try leaving and rejoining. If you're still having problems, you've checked your headset, you've closed all your other browsers, you've tried F5, then drop us a message in the Q&A chat box and we will do our very best to assist you. So moving on then to our agenda for today, you may well notice the change in acronyms in the name of this webinar. So we were doing a series of webinars on the LPS, the Liberty Protection Safeguards. As I'm sure you'll all be aware, the LPS has been shelved until at least after the next general election, which is autumn 2024. We think it is likely to be a permanent shelving of the LPS, as there is no indication that any potential incoming parties at that next general election would be picking it up and moving forward with it. So I think it's best that we continue on the basis that LPS is unfortunately dead in the water. And it's therefore really important that we refocus our efforts on the Mental Capacity Act and Deprivation of Liberty safeguards. And to that end, we've got Amy talking to us this morning about the Mental Capacity Act draft code of practice, and specifically the parts of that which relate to mental capacity, which may have got slightly sidelined by all the sections relating to LPS, but we'll be picking up on those and what key changes we see there from the current code of practice. We'll then be moving on to Claire, who's going to be talking to us about the case of JS and the important role that that plays in this issue we're seeing about the interface between the Mental Health Act and the Mental Capacity Act, particularly when it comes to detaining patients in hospital. And then finally, we'll be moving on to Jo, last but not least, who's going to be talking to us about COP-11s. So that is the process by which you seek to authorise a deprivation of liberty in the community through the streamlined process. And Jo's going to be talking through some troubleshooting with us on that. That's certainly an area that we're seeing people starting to refocus on now that LPS has been shelved, and we're getting lots of questions coming up on that. And we want to make it as easy for you as possible. So hopefully that troubleshooting will help with that. And then we will have plenty of time for questions at the end, but please do put questions into the chat box as we go along, and then we will pick up on some of those at the end. I think that is probably everything from me for now, so I will hand you over to the lovely Amy. Thanks, Amy.
Thank you, Emma. So as Emma has outlined, I'm going to spend 20 minutes telling you all about something that's not actually in existence yet. So bear with me, there is a reason for that. And hopefully there will be some points that you get out of this that will still be useful for you in terms of your day-to-day practice. So I am, as I say, I'm going to cover basically the updated but very much draft code of practice to the Mental Capacity Act. before I do that, I thought it might be worth spending a minute or two just outlining and reminding everybody what the code of practice is and what status it has, and when it was sort of first introduced in the first place. So it was first published, the code of practice, in 2007 alongside the Mental Capacity Act. Section 42 of the Act required that the Lord Chancellor produce a code of practice for the guidance for people who have responsibilities basically under the Act. And in its current form, so not the updated draft, is about 300 pages. And the aim of it is to provide practical guidance and information on how the Mental Capacity Act actually works in practice to people who care and who work with people who are unable to make decisions for themselves. And it explains how the Mental Capacity Act sort of operates on that day-to-day basis. So it is guidance. It's not instruction, so to speak. However, for those who depart from following it in some way, should provide good reason why they have departed from it. So it's got strength there. The code also has statutory force, which basically means that certain categories of people have a legal duty to have regard to the code when working with or caring for adults who may lack capacity to make decisions for themselves. And I've mentioned on the slide there the sort of categories of people who have that legal duty. Some of them are, fairly self-explanatory, lasting power of attorneys, deputies appointed by the Court of Protection, IMCAs. The last two categories are a little bit more vague, but they're embellished in the code itself. So people who are acting in a professional capacity may include a variety, obviously, of healthcare staff, a lot, if not all of you here today, social care staff, others who may occasionally be involved in the care of people who lack capacity to make specific decisions. It can also include ambulance crew, housing workers and police officers as well. And then the last category of people is those being paid for or asked for in relation to a person who lacks capacity. So they are the people who may be care workers in a care home or providing domiciliary care services, and others who have been contracted to provide a service. So as you can see, it's very broad in terms of the categories of people who must have regard to the code when working in their sort of day-to-day practice, so to speak. So as I've mentioned in the bottom of the slide, and I'm not going to spend an awful long period of time talking about the LPS, as we've done that and we know that that's not happening anytime soon, but it serves to say that we know that the LPS is delayed beyond the life of this government, this parliament, but where does it actually leave us in terms of the, if I can call them, the MCA parts of the draft code of practice? I've set out a sort of potted history there of the LPS and where we are now with that. And as you'll see on the slide, there was a hint in the June announcement from the government, or a response, if you like, that actually they understand and acknowledge that the MCA code of practice still very much needs attention and needs to be updated, and they are committed to doing so. And they will still review the responses to the 2022 consultation with a view to updating the MCA parts of the amended draft code, and I'll get to what they are in a moment. Clearly a lot of work by everybody, and a lot of you here today went into reviewing and revising the code or providing feedback during the consultation period on it. So my view, and I think those shared by my colleague, is let's use this time that we now have, not implementing LPS, but to understand this draft amended code and embed perhaps the more key and uncontroversial, if I can put it that way, proposed changes into our and your everyday practice. Because I have to emphasize, it is still a draft code. It's not finalized, but there are aspects of it, which I'm sort of drawing out in my session today, that will still be very much of use to you in your sort of working practice. So that was in June. I'm not aware of a formal update to that. If anyone else is, please do feel free to share that. So we're sort of still waiting for what that might look like. But what are the key changes that were proposed in the draft updated code? And one thing I noticed when I was doing a bit of a cross reference between the existing code and the updated draft code is there is this real emphasis throughout on empowerment and autonomy, and that principle of not assuming that someone lacks capacity, going further into what practicable steps should be taken to support someone to make capacitous decisions. So that really is a key sort of thread, if you like, that runs through the updated draft code. Clearly that's the root, and the key ethos of the MCA, so should very much be present throughout the code itself. What the government did is they published one draft updated code of practice to basically ensure that the MCA and the updates that we've seen throughout the years since it was introduced firmly embedded into the LPS procedure. So there are sort of chapters that are your more MCA chapters that are sort of chapters 1 to 11 of the updated code, and to an extent also 21 to 26, and the ones in between are more pure LPS aspects of the code. What's difficult is the LPS process, and the rules around that are intertwined in chapters 1 to 11 as well. So it will take some time to unpick all of it if we are not proceeding with LPS, but we do want to update the code. But at least chapters 1 to 11, you can really see what changes have been made aside from the LPS aspects of them, if you like. So 3 key themes that I identified when I was reviewing the updated draft code is they can be sort of broadly split into sort of 3 key areas. One is the legal aspect. So clearly there've been, there's been a great deal of case law since the Act was brought into force that has shaped and defined the law basically since it was introduced. And what the code does is it references those cases and embeds the key principles from them into the code itself. There's the practical aspect. So what it does is it tries to really just bring to life and bring up to date the developments in the ways that you all work and what is good practice essentially since the MCA came into force. But clearly there's been a lot of learning that's gone on in the last 15 years in terms of actually applying the principles of the MCA. And then, as I've put it on the slide, tackling the trickier concepts. So what it aims to try and do without being overly prescriptive is to address some of the more challenging concepts, which again, I'm sure you've all encountered and still do, which include, considering and assessing capacity and how that should be done, fluctuating capacity, which is just inherently, can be a challenging legally and on the ground, obviously, to deal with, and executive functioning as well. And I've noticed there's a question around that, which I'll have a look at and answer in the chat or perhaps at the end. But so that's sort of broadly how I've split the key sort of areas of amendment, if you like, to this draft code of practice. I've said a deep-ish dive into these updates, starting with the legal updates. And I say ish because there are, so many updates legally to this code and lots of cases that are referred to. So I can only really draw out some examples for you, really, than go into them all at this stage. I do a bit of a deeper dive into the MCA updates on our website if you wanted to have a look at that. So what's handy just for us lawyers, and I'm sure for you, is there are actual references to the case law in the footnotes for a start. So there's links to judgments in there, which is really handy and I think a great step Obviously, the code has to be quite selective in how many and which cases to refer to, as there have been, you know, a huge amount of cases since the Act was brought into force in 2007. A couple of examples. In paragraph 7.21 onwards, there is the reference to the guidance in the NHS Trust and Why case from 2018. And this gives guidance that's sort of lifted from that case in relation to when to apply to court and when you don't need to apply to court in certain medical treatment cases. And we know as well, if you're dealing with medical treatment matters, there is guidance from Mr. Justice Hayden, which followed this case and published in January 2020 about those circumstances where an application to the Court of Protection should be considered, or in fact should be made. And that's if a decision is finely balanced, there's a difference of medical opinion, there's a lack of agreement, or there's a significant interference with P's rights in some way by the Act being proposed. So the code goes into some detail on applications to the court in sort of life-sustaining medical treatment cases. At paragraph 5.25, there's reference to commencing the best interest process by identifying the available options, particularly those that are on this webinar who are perhaps on the sort of commissioning side, that commission packages of care for people in the community. This arose from an important case of N and A CCG from 2017. Again, this is about stressing the importance of identifying what the available options are at the outset before a best interests process is commenced, essentially. So the Court of Protection cannot force a public body to present an option as available which isn't available, but it can scrutinise that decision making, and it often does. So again, that's a really important legal development, and it's one that's now reflected in the code. Finally, and just another example, the emphasis on the best interest process being a holistic one, as per the Aintree and James case from 2013, is referred to in the code. So again, not looking at things purely from a sort of clinical perspective, but on a much broader perspective in terms of someone's perhaps cultural, religious beliefs, etc. So that holistic approach to best interests is also reflected within the code. So that gives you a little bit of a, you know, a brief rundown of some of the key legal updates, but there are many others, I must say, especially in relation to sort of capacity, etc. So moving on to some of the more practical updates to the code, it aims to reflect some common and sensible working practice which have clearly developed on the ground over the years. Some examples of those are remote capacity assessments, for example, are essentially a thing of the past being the COVID pandemic, and they should be the exception rather than the norm. The guidance on when capacity assessments should be reviewed, so 4.60 of the code said whenever a care and support plan is being developed or reviewed at other relevant stages of the care planning process, and as particular new decisions need to be made. So there's some specific guidance on when capacity should be reassessed, which I think is helpful. Interestingly as well, and something we obviously come across quite frequently when we're supporting our clients, is that recognition that there are often an MDT approach to best interests decision making. So identifying who the decision maker isn't always straightforward, or it may not be that there's sort of one clearly identifiable decision maker under the best interest process. And what that says is, you know, there might be various different sort of specialities involved in the person's care from different organisations, and it's important that there is one person who is identified as having the responsibility of coordinating that process, but to some extent they may delegate that to others. on a sort of practical level. But what it does say is there has to be someone who is still the decision maker in some way. So it sort of gives a nod to that MDT approach and how that can be sort of facilitated, but still identifying a person or a organisation that leads in terms of the decision making. There's more guidance on recording best interests decisions. So there's a good few paragraphs from 5.102 to 5.108 on recording best interest decisions, and that more serious decisions will require more detailed records, which sounds very obvious and sensible, and it is, but there's more sort of guidance on what that should look like and how best to do that. And the question or the issue which we come across quite regularly, and I know is a difficult one, is when do you actually make an application to the Court of Protection should a decision from the court be required? And there's reference to early consideration must always be given to how long is perhaps reasonable to spend seeking to support the person to make their own decision, or perhaps reaching agreement to apply to court. But what is reasonable is very much open to interpretation, and it's fact dependent. So in our view, if you're unsure, seeking some advice about A, whether an application is required, or B, when to make one, is certainly worthwhile. And obviously an application can always be withdrawn if it is indeed made. So there's a little bit of guidance on that, but not a great deal. And finally, who should actually bring the application to court? And there's a bit of guidance in paragraph 7.44. Some examples, if social care staff are concerned about a decision that affects the welfare of a person who lacks capacity, then the relevant local authority should make the application. Medical treatment, it would be the trust or potentially the ICB if it's treatment in the community. What it doesn't do is go into situations where perhaps there's a jointly commissioned package of care. So would it be potentially the ICB or the local authority? And I think the idea is that should be subject to locally agreed protocols or sort of even informal agreements, I suppose, although the more formal the better. But it at least, again, it acknowledges that there are kind of commissioning arrangements in the background that might determine who should bring an application to the court if one's required. So that's a few of the practical updates, if you like. Lastly, the tricky concepts, as I call them, the ones that we often are asked to support our clients with, and obviously them supporting the person with as well. First of all, there is a reordering of the two-stage capacity test. And I think this is probably one of the most significant changes in the updated draft code, because it's fundamental to the decision-making process. So the test has essentially been reordered, and the idea is to prevent automatic assumptions that a person can't make a decision because of their condition or their impairment of the mind or brain. So what they're suggesting is that actually you look at whether the person is able to make the decision with support if required, and if they can't, then is there an impairment or disturbance that is affecting their ability to make that decision. So it's making clear that the first question is about ability to make a decision, the understand, the retain, the use and weigh the relevant information, and only then, if they cannot, whether that is due to that disturbance or impairment in the functioning of the mind or brain. So as I say, there's a clear groundswell of support really for this reordering, and I expect it to be embedded within the code at the point it's finalised. There is some reference to executive functioning as well, and there is a case study on executive functioning, because again, I know this is something where there's it's a developing sort of area in terms of how that impacts on ability to make decisions and capacity. And what the code does is talk about that evidence of a repeated mismatch between what a person is saying and then what the person does. And it is drawn out, as I say, in a case scenario of Ms. L, who has issues around sort of impulsive eating. So there'll be very many other examples of executive functioning issues, but at least there's some meat on the bones there in terms of how that might present and how that might affect someone's ability to make decisions. Again, with fluctuating capacity, paragraphs 4.51 onwards, spend some time on fluctuating capacity and trying to distinguish what are those isolated one-off decisions versus those that have to be made on more of a repetitive basis over a longer period of time. You might also have seen it referred to as the micro versus macro decision-making issue, which obviously challenges practitioners and courts as well. So there is a few paragraphs on fluctuating capacity. There's also an interesting case scenario on involving Mr. R on page 53. It just jumped out at me, who has early onset dementia and makes a valid LPA for health and welfare effectively within the hour that he is able to retain and understand the information. And so whilst he has capacity to make that decision, and I won't say much more than that because it is a case scenario. It may not make it to the final code, but it was just an interesting one for me to pick up on. And the draft code, paragraph 16.17, approaches the issue of the conveyance or transfer of P from one place to the other. Again, that's something where we we can be instructed in relation to quite frequently. And it recognises that in some cases there may be no alternative but to move a person from A to B, but it really explains the limits that the MCA has in section 5 in relation to carrying out that act and in what circumstances you will possibly need to apply to court to decide what's in that person's best interests and where they should live. So there's not a great deal on that, but it does sort of align with what we have been advising our clients on in relation to that point. So that's a bit of a summary, and it really is a summary. As I say, our website, I did when the code first came out, I did a bit of a deeper dive on the key sort of changes, and you'll be able to find that on our website. But I've drawn out some of the key ones and things for you to be thinking about in terms of, as I say on the slide, refresher training on MCA. So what we've been advising our clients is, okay, so LPS is not happening, but there's a lot of work that has been done to refresh this code, this draft code, and really refocus on the MCA, which is the core sort of principle underlying any authorization of a DOL, whether that be through this LPS or through some other system. So refresher training on MCA obviously is key, and I know a lot of you are already doing that, and I've been helping my clients with that recently. Reviewing and updating your MCA policies and procedures as well to embed as I said at the beginning, the less controversial elements of the amended code of practice. Familiarising yourself with the MCA parts of the updated draft code as well. Obviously, it takes a bit of reading. It's a really long document. I've found it quite helpful to have the existing code up alongside the amended code and just sort of flagging the key changes really, and obviously keeping an eye out for other government announcements on what is yet to come in terms of the amended code of practice. I've put a useful resource there. Link is the capacity guide website, which contains some really helpful information about assessing capacity, but also flashpoints as they describe it. So and it deals with that executive functioning and fluctuating capacity, and if someone perhaps doesn't engage with a capacity assessment. So I've found that a useful resource, and ones that I sometimes direct my clients to have a look at as well in those sort of trickier cases. I've put our email address down, our team email address as well, if you have any queries in relation to this or anything else, of course, that comes up. So I think that concludes my section just on time as well, which is great. I thought that might have been too much to fit in 20 minutes, but I will hand over now to Claire Christophilus, who is going to spend some time talking about a case that deals with the MHA and MCA interface. Claire, I'll let you do the rest of the talking on that because I know it's a hot topic at the moment.
It is. Thank you, Amy.
Thank you.
So, yes, I'm going to talk about the case of JS as a sort of means of updating around deprivation of liberty for young people. And we'll also touch on how this case is perhaps going to extend into sort of the child arena as well. If you've not heard of JS, don't worry, we're going to go through the facts first of all, and then come on to kind of what that means in practice and what the implications of it might be for clinicians. It is a tricky area. I was involved in JS in the summer, and I think I can only say now that having reread it and spoken to lots of people about it, I think I finally understand it enough to explain it to people. So it does take some time to get your head around. But there are also, it is a relatively new judgment. It is being applied in other cases in the court of protection, fairly frequently being referred to. So it is, in a sense, a bit of a developing area. And as I'll come on to a bit later on, I'm not sure that we've heard the last of this issue, and there may be more to come. So first of all, I'm just going to set the context in terms of what JS was considering. So JS was a case in the Court of Protection to authorise the deprivation of liberty of a 17-year-old in a general hospital. And the court was considering whether she was ineligible to have that deprivation of liberty authorised under the Mental Capacity Act. And the part of the MCA that we were all very focused on was Schedule 1A, and specifically Case E, which says that if you are within the scope of the Mental Health Act but not subject to any of the mental health regimes, then you are ineligible to be deprived of your liberty under the Mental Capacity Act. In other words, should you be detained under the Mental Health Act instead? And the purpose of introducing Schedule 1A was in part to promote a consistent legal framework for the detention of people in hospital for treatment of mental disorders who were objecting to that treatment, so that patients, whether they had capacity or not, were treated in the same manner. And so you didn't have this disparity between people being detained under the Mental Health Act if they had capacity, and detained under or deprived of their liberty under the Mental Capacity Act if they lacked capacity. So that was the kind of policy reason behind it. So JS itself then, it was initially a case in the court in Manchester before His Honour Judge Burrows, who was sitting as a Tier 2 judge. And the appeal went to Mrs. Justice Tice, sitting as a Tier 3 judge in the Court of Protection. So JS was a 17-year-old young person. She had diagnoses of autism spectrum disorder, learning disability, ADHD, and attachment disorder. And following attempts to hurt herself at home, she was brought to the emergency department and then admitted to the Trust's adult acute ward. So this is just a general medical ward, not a psychiatric ward. She was initially detained under Section 2 of the Mental Health Act, but then assessed as not meeting the criteria for detention under Section 3. So a situation that we see frequently in hospitals. GS was medically fit for discharge within a few days of her admission. Luckily, she hadn't done herself any physical harm. But the obstacle to getting her discharge was that everybody involved in her care, social care, professionals, healthcare, and JS's mother all agreed that it wasn't safe for her to be discharged home without a package of support in the community. Because without that, she was just likely to self-harm, and there was a risk that she might inadvertently cause her own death. And so the local authority was trying to put in place an appropriate package of care. And in the meantime, she was on the ward, as the trust described it, as a place of safety after the Section 2 expired. And when she was on the ward, she had a care plan designed to keep her safe, to stop her from leaving the hospital and from hurting herself. And that included 2-to-1 supervision, locked doors, room searches, and when it was necessary and proportionate, she was subject to physical restraint and oral sedative medication. She had a capacity assessment. She was deemed to lack capacity to consent to her hospital admission. And so the trust made an application to the Court of Protection to authorise that doll in hospital, bearing in mind that she was 17, so the DOLS authorisation couldn't be applied for. So it had to be done via a court application. So the first instance decision before His Honour Judge Burrows, at the first hearing, the judge did authorise her deprivation of liberty on an interim basis, but he expressed concerns that applying case E of Schedule 1A, that she might be ineligible to be deprived of her liberty under the MCA. In other words, he thought that she was within the scope of the Mental Health Act. And so the trust was invited to file submissions, and then the judge delivered his judgment, and he did confirm his view that JS was in fact ineligible to be deprived of her liberty under the MCA. And what the judge said was that the Court of Protection was being asked to authorise treatment, i.e. the physical restraint, the chemical restraint, the enhanced observations, the locked doors, all of which was required as a result of a manifestation of JS's mental disorders. And he said that she could, that being the test, but also in his view that she should actually be detained under the Mental Health Act. And the judge reached that view notwithstanding that there was evidence from the treating psychiatrist as to why JS didn't meet the criteria for detention under Section 3 of the Mental Health Act. And in fact, being in hospital would be detrimental to her well-being. They said that there was no treatment in a psychiatric unit which would help JS. But what the judge said was that decisions to use the Mental Health Act can't be viewed in isolation from what's available elsewhere at the time that the decision is made to detain or not detain. And in this case, there was no option but for JS to remain in hospital. So it was just about what legal framework should be used to authorise that, and whether that should be the Mental Health Act rather than the Mental Capacity Act. And so the trust sought permission to appeal. They were very concerned about the far-reaching consequences of this judgment, and thought that Section 3 had been wrongly applied. However, the appeal was unsuccessful. It came before, as I said, Mrs. Justice Tice, who upheld the first instance decision. She found that there was no reason or sound basis to depart from the what the decision maker thinks test, which was established in GJ. And that's essentially what His Honour Judge Burrows did at the first instance, was applying that test. And the decision maker is the COP judge, not the psychiatrist treating JS. So it's what he thought, and whether, in his view, she could be detained under the Mental Health Act. And so Mrs. Justice Tice refused to depart from that. The trust had proposed a sort of public law type test, which would only allow the MCA decision maker to interfere with the Mental Health Act decision maker if their decision was not logical or rational. But the judge felt that that would probably lead to more uncertainty and undermine the purpose of the statutory legislation. So she concluded that it is for the MCA decision maker, in this case the COP judge, to decide whether or not he could be detained under the Mental Health Act, notwithstanding the conclusion of the treating psychiatrist. And in terms of whether her care plan constituted treatment, the judge noted that medical treatment is very broadly defined. It's not limited to treating an underlying or core mental disorder. It does include treating its manifestations. And on that basis, she agreed that JS's care plan went beyond simply providing her with a place of safety. It was treatment for a manifestation of her mental disorder, namely her autism. And therefore, the judge was entitled to conclude that she was a mental health patient receiving treatment for her mental disorder. And the judge also found that Section 3 had therefore been appropriately applied in JS's case. So that one of the reasons the trust brought the appeal was because they were concerned about judges essentially making decisions about whether patients should be detained under the Mental Health Act, notwithstanding what the psychiatrists were saying. And the worry really is that if they're not detainable under the Mental Health Act, according to the psychiatrists, but the COP judge is also saying they're not eligible for their deprivation of liberty to be authorised under the Mental Capacity Act, then hospitals may be left with no legal framework to authorise the DOL of patients like JS. But equally, they won't feel able to just open the door and let them leave, because that's likely to result in them coming to harm or causing their own death. So essentially what the court said is that clinicians need to be asking themselves these 3 questions in this order. So first of all, is the person a mental health patient, meaning are they accommodated in hospital for the purpose of being given medical treatment as defined by Section 145 of the Mental Health Act? And as I said previously, that is very broadly defined. And then if you satisfy that limb, you move on to consider whether P is objecting. Usually that's a fairly straightforward question, but in some cases it might be more difficult to establish that. And then finally, could the person be detained under the Mental Health Act when you apply the Section 3 criteria? And as I said, in JS, the courts were clear that a care plan which is designed to prevent a patient from leaving hospital or harming themselves, rather than conferring any therapeutic benefit, can constitute medical treatment if it arises as a consequence of the patient's mental disorder or one or more of its manifestations. And I've spoken with a lot of clinicians about this judgment, and they're understandably concerned that it might encourage the detention of patients under the Mental Health Act, even when it's not appropriate for the patient to receive treatment in hospital and appropriate medical treatment is not available for them. But what the judge said in response to that in JS was that, again, you can't look at it in isolation. There's no other available option available to keep the patient safe in the community. And if they're detained in hospital in any event, then they should be detained under the Mental Health Act rather than the Mental Capacity Act. And very recently, this has been reiterated in the context of children. So this was another decision of His Honour Judge Burrows, who, as I mentioned, was the first instance judge in JS. And this case involved decision-making for a 15-year-old child with ADHD who was subject to significant restrictions to stop her from self-harming. And what Burrows says was that he had essentially considered this in the context of a young person in the JS case. And although he wasn't considering ineligibility because it was in the High Court rather than the Court of Protection, he was discussing his concerns about how CAM's provision and Tier 4 decision-making have to look at the social care provision and what's available when making decisions under the Mental Health Act. And so whilst if there's a less restrictive option available, the child shouldn't be detained in a psychiatric facility. But if treatment in hospital, but if the placement is not available within a reasonable timescale and they have to be in a hospital anyway, then detention under the Mental Health Act should be considered in that context. So I think we're seeing the principles in JS not only apply to 16 and above in COP, but trickling down into the inherent jurisdiction arena. There was an interesting upper tribunal decision after JS. So it was heard before JS, but the decision wasn't published until afterwards. So it wasn't a case that we were able to refer to during the JS appeal. And it's quite difficult to reconcile these two decisions. They are looking at things in a slightly different context. So this was a patient who was already detained under Section 3, and she was challenging that detention and then appealed to the upper tribunal. And it was a woman with diagnoses of ASD and PTSD. And she argued that the criteria for detention was not met because the clinical team accepted that the treatment that she required was not available to her in an acute psychiatric ward. Being on the ward was detrimental to her mental health, and she was simply being detained because if they let her go, they were worried that she was going to harm or kill herself in the community. And so essentially, the judges in that case, the tribunal judges, found that the first tier tribunal was wrong in deciding that appropriate medical treatment was available to RB in those circumstances, which essentially is what was being argued in the JS appeal, but that was unsuccessful in that jurisdiction. And there's just some quotes here from the upper tribunal decision about looking at appropriate medical treatment in the context of the Mental Health Act as a whole, looking at what the purpose of that statute was, and essentially finding that it wasn't intended to allow people to be detained for the sole purpose of ensuring their physical safety. And they said to interpret the provisions as permitting detention where the only treatment available is provided for the purpose of maintaining physical safety without treating the mental disorder itself would be to frustrate Parliament's statutory purpose. And they also said that it was based on two misunderstandings. First, that containing the risk of physical harm was capable of amounting to medical treatment. And secondly, that treatment can be appropriate even when it's not tailored to the patient's diagnosis. So it's, as I said, difficult to reconcile that with JS. And I think it is likely that we've not heard the last of this issue, and the courts are currently and will be asked to consider ineligibility more frequently following JS. What I will say at the moment is that, of course, clinical judgment shouldn't be compromised in assessing eligibility for detention under the Mental Health Act. Clinicians have got to apply the statutes to their patients as they consider appropriate. But it is equally as important to be aware of JS, to be aware of the questions that the court might ask about it, and to be prepared to justify any conclusions that have been reached. Just finally, the judge was asked to consider a roadmap to resolving disputes between Mental Capacity Act and Mental Health Act decision makers. So in JS, the issue of ineligibility was before the court of protection because, as I said, JS was 17. But in the majority of cases where you've got adults 18 and above, the deprivation of liberty safeguards will be used. And so the dispute might then be between the eligibility assessor or the best interest assessor, i.e. the MCA decision maker, and the patient's treating psychiatrist, who would be the MHA decision maker. So Mrs. Justice Tice was invited to provide a roadmap to assess professionals when there's disagreement between those professionals. She declined to be overly prescriptive because each of these cases is very fact specific, but she did direct that there should be discussions between professionals in the spirit of cooperation and appropriate urgency, and to ensure the relevant professionals have reviewed and considered relevant evidence, and if required, further inquiries can be made. So essentially proposing some sort of review process in a collaborative way between the relevant decision makers. If that doesn't work, which might be optimistic to think that it would be, given that people have probably already carefully considered these decisions. But if there remains disagreement, the Trust has various options. It can make a referral to an AMP under the Mental Health Act and see if they're prepared to authorise the detention, even if it's only on a short-term basis, whilst trying to work towards that person's discharge. They can seek detention in an alternative setting, such as a care home, where ineligibility under the MCA doesn't arise. They could stop depriving P of their liberty, i.e. just let them go, but as mentioned, that comes with risks. And finally, if the ineligibility decision was not already made by the Court of Protection, so if you're in the DOLS arena, then you can apply to the COP for a determination of whether P is eligible for detention under the MCA. The court made it clear that they're not inviting that as a regular occurrence, but it might be appropriate to do that in particular circumstances. And there's some guidance in the judgment as to how trusts should approach that in terms of filing evidence addressing the three questions that we went back to before, in terms of whether someone is a mental health patient, whether they're objecting, and finally whether the Section 3 criteria is met or not. So that is the end of JS. Thank you for listening, bearing with me. I'm going to pass over now to Joanna, who's going to talk about COP/DOL 11.
Thank you, Claire. And good morning, everyone. So I'm going to talk to you this morning about COP/DOL 11 applications, and in particular some troubleshooting common and recurring issues and how to get around them. Just want to acknowledge that COP/DOL 11's in the main relevant for commissioners of care, so particularly ICBs and local authorities, and those working on behalf of ICBs and local authorities. So that's one of the reasons we put my presentation at the end. I'll try not to be offended if the attendance list plummets during the course of what I'm saying, but I do recognise it's not relevant to all of you. If you do hang around, though, we'll hear the Q&A session at the end, so you'd be very welcome to stick around. And, you know, perhaps those in hospitals, for example, dealing with Court of Protection applications for 16 and 17-year-olds might find it useful to hear some of the queries that the court raises for these applications, because it's likely that the Court of Protection would have the same considerations in similar cases. So just to highlight some of our credentials in terms of COP/DOL 11 and the experience that I'm bringing to this presentation. So we've been dealing with applications made under the REACT procedure since the case was heard. We've dealt with many hundreds of applications over the years on behalf of both ICBs and local authorities, including applications at scale, so bulk cases for some of our clients, and that's allowed us to develop some of our systems to streamline the process further to make this easier and more cost effective for ourselves and our clients. So that's the experience that I'm bringing to this presentation. So just to catch people up if you're not sure what I'm talking about, a COP/DOL 11 is an application made under what the court calls the streamline process to authorise deprivation of liberty that's occurring in a community setting, for example, a supported living setting, or in somebody's own home where the deprivation of liberty safeguards don't apply. And obviously, one of the things that LPS was supposed to come and fix was that gap. And now that we don't think LPS is happening, COP/DOL 11 is very much back on the agenda for a lot of organisations. So this is an overview of what I want to talk to you about. So first of all, the backlog. So those of you who are dealing with COP/DOL 11 applications will likely be very familiar with the backlog of those applications once we've made the applications to court, it has taken many months, sometimes 9 to 12 months to actually receive a response back from the court. And we've raised this with the Court of Protection users group and have had an update that there was a new cohort of judges brought on board to work on applications that were made since April last year to allow the existing cohort of judges to work through the backlog. And we're assured now that those pre-2022 cases have all now been dealt with, which I very much hope that's the case. And now all of the applications are being dealt with by all the judges, and they expect the backlog to be cleared very soon. And we have noticed that we are getting much more speedy responses back from the court. Another issue that we've noticed is an increase in what are called maybe orders. A maybe order is when the court doesn't immediately authorise the deprivation of liberty. It doesn't immediately provide the final order. Instead, what it does is it requests further information, updated documents, or raises some other issue. There are some common themes that we've noticed recently around what sort of issues the judges are making maybe orders about, and I'm going to cover each of those in turn. But just generally, it's quite easy to let the maybe orders get to you. It can be frustrating when you feel like you've provided the court with all of the information that it requires, and they're now coming back and asking for more information. In addition, there is some inconsistency around what one judge might ask about or not be happy with, whereas another judge might have accepted that evidence and approved the application. So they can lead to some frustration. A lot of the issues that are raised in maybe orders are not based on any written guidance that we're aware of, so it's not something that we could necessarily anticipate from the case law or a practice direction, but it seems to have developed in practice from what the judges will and won't accept. And like I say, there can be some inconsistency, so it's very difficult to say the court won't accept this or the court will accept this, because it does seem to depend on the judge and how they feel on the particular day. Having received many a maybe order, my philosophy is to not take it as criticism, to accept that we couldn't have anticipated the request for further information usually, and to simply provide that, and understand that the judges are dealing with serious decisions. They're being asked to make that on the papers, and if the judge requires some more information to give them the reassurance that what they're being asked to authorise is appropriate, then let's just get on with it and provide that information and not take it personally. So I'm hoping that that philosophy helps the teams dealing with these applications and our clients, not to say we've missed something, we've made a mistake, we haven't provided the correct information. It's just that this particular judge on this particular day wants a little bit more information. So as I say, I'm just going to provide some more detail in a second. Other themes to flag with you are around tenancy agreements, and just a reminder about the new COP3 capacity assessment form, which I'll come on to in a moment. So one of the issues that we tend to see maybe orders about is the Rule 1.2 representative and the choice of 1.2 representative. So a quick reminder of that. The 1.2 representative is an important role as part of the streamlined procedure which allows the court to dispense with the requirement for P to be a party to the proceedings, be represented, or have a litigation friend. So the Rule 1.2 representative is an important safeguard that checks that someone outside of the care provision is happy with the arrangements. So it's been clear all along that the Rule 1.2 representative cannot have a conflict of interest with P, and as part of the form, the applicant, so probably the ICB or a local authority, has to endorse the Rule 1.2 representative as someone that's suitable to act. So generally it's been clear that someone who's paid as part of the care package, even when that's a family member who receives payment for their care provision, can't be a 1.2 representative, because that would be a conflict of interests with P. The court couldn't really be reassured that that person is objectively saying that the care is appropriate if it's their livelihood may also depend on the care package being continued. We are starting to see an extension of that to both unpaid carers and also people who live in the same house as P. So whether or not someone is actually part of the care package, we are seeing increasingly that if we've nominated a 1.2 representative that lives in the same house as P, the court won't accept them as 1.2 representative. So again, we've raised this with the Court of Protection, and the rationale that we've been given is that the Rule 1.2 representative needs to have sufficient distance from the implementation of the restrictions in order to be able to take a view from P's perspective as to whether the restrictions are proportionate. So we do expect to see this continuing. The court is less and less likely to allow the 1.2 representative to be someone involved in the care provision in whatever capacity or living in the same house as P. So I think it's probably clear to those of you working in the COPDOL 11 arena that that will significantly narrow the pool of available people to act as Rule 1.2 representatives. We are having to look a bit wider in families, ask grandparents, cousins, aunts and uncles to step in and act as a 1.2 representative rather than parents or spouses. One way, if there really isn't anybody else, would be perhaps to file a statement proactively alongside the COPDOL 11 application, addressing these issues head on and explaining why the applicant believes that this person is suitable to act as 1.2 representative, or a statement from the 1.2 representative themselves explaining why it's appropriate for them to act in that role, notwithstanding that the court may have some reservations. But ultimately the impact is that this is likely to lead to more demand for court of protection visitors to carry out their role if there's no one suitable to act, and anyone willing potentially being dismissed by the court. So something to be aware of and perhaps address head on along with your applications moving forward. A common theme around the maybe orders is the care plans. I always say that the care plan is a key, crucial document under the COPDOL 11 application. If you've been around as long as me, you might remember the judges used to sign the care plan and send it back to you with the final COPDOL 11 order. And I've not seen that more recently, but I think it just underpins that what the DOLS authorisation is doing is authorising the care plan and the restrictions in those care plans. So one thing is important to ensure that care plans are of sufficient quality and include details of the restrictions so that a judge can be happy to authorise it. One issue which is hopefully going to happen less and less with the backlog being cleared is that the care plans are considered to be out of date once they're over 12 months old. And this is really something that is consistent in terms of the ask from the court. So, you know, you can see that with the care plan being so important, the judges want to ensure that it is an up-to-date care plan when they sign it. So it needs to be within 1 year old. With not knowing how long this can take, it's a little bit difficult at the moment, but you need to try and provide a care plan as recent as possible when making the COPDOL 11 application. And what we're trying to do is proactively request a care plan if we diarise the date that the care plan becomes out of date, if you will, and request that and file it proactively, so that the judge doesn't need to send us a maybe order asking for an up-to-date care plan. Also, some common and consistent acts around the care plans which you know, you can anticipate and you should comply with are that it's signed and that it's dated, and that the address of the placement, I've not put that on the slide, but the address of the placement also needs to be included on the care plan. Something that the court does tend to find difficult to grapple with are situations where there's lots of different care plans. So this is when we're trying to use a provider care plan, and they might have multiple different care plans, for example, moving and handling, eating and drinking, accessing the community, going to the toilet, things like that, rather than one single care plan. And I've taken the view that it's not really for a judge sitting in court in London to dictate how a care provider wants to direct its staff in terms of care plans and how that is written. The judges would prefer a single care plan which allows them to authorise everything all together. If there is a single sort of overarching care plan, then great. You know, what the judge is looking for is the restrictions at the end of the day. But if you are dealing with lots of different care plans, one way that seems to be acceptable to the court is simply bundling those up into a single PDF document, and that seems to be doing the trick. One suggestion from me has been asking a provider to prepare a cover sheet for the care plans, and then you can have the cover sheet signed and dated and include the address on the front page, and that seems to be acceptable at the moment. Also, we're seeing more and more judges asking for more detail about PRN medication and physical restraint. So there are specific questions in the form around the use of PRN medication and physical restraint. Where it is in use, you can anticipate that the judges will want lots of detail around that. So it does need to be clear. For example, PRN, how often is it used? When was the last time it was used? Who decides whether or not to give it? What's in place around that? And the judge will want to see a specific care plan or protocol around the use of PRN medication, and similarly around physical restraint. So again, that's something that you can anticipate as part of the process and have that ready when you file your application in an effort to reduce the maybe orders. So consultation, again, is another area where we're getting lots more maybe orders. So reminder that the REACT procedure is not suitable if there is an inability or a failure to consult with relevant people, and they're listed as any donee of LPA or deputy, and if possible, at least 3 people from the following categories: anyone named by P as someone to be consulted, and anyone engaged in caring for or interested in their welfare. So just to give you an example, last year I had one application where an ICB had consulted with P's mum, who was across everything very involved and up to speed with everything that was going on. They hadn't consulted with P's dad, merely because mum just knew her stuff and it wasn't felt necessary. However, the court came back with a maybe order on that and wanted dad to have been consulted, and didn't think it was good enough that mum kind of was a spokesperson for the family. But we are also seeing an increasing number of maybe orders which require consultation to be undertaken with a member of the care team. So that's something to bear in mind. So they are obviously engaged in caring for or interested in the welfare of P. I would suggest that perhaps we hadn't thought that to be necessary, as they're clearly part of the care package, but it is becoming more frequent that the courts want to hear from a member of the care team as part of that consultation. Just quickly, some final points. So moving away from the maybe orders, tenancy agreements is something to bear in mind when making a COPDOL 11 application, and there is a requirement for the court to authorise someone to sign a tenancy agreement on behalf of P if there's no lasting power of attorney or deputy for property and financial affairs with the power to do this. I think previously there was a lot of flexibility and perhaps people not really aware of the requirements of the law around this, where anybody, mums, dads, the commissioners used to sign tenancy agreements on behalf of P, and no one particularly worried about the legalities around that. But landlords are becoming more savvy, and it is correct on behalf of P to ensure that they're adequately protected, that the person needs to be properly authorised to sign this. There is a way as part of the COPDOL 11 application to ask the court to authorise this, but it does need to be thought about, particularly if P's moving into a new property. We need to think about it in terms of timing the application, whether it needs to be marked as urgent for that reason if P's not going to be allowed to move in beforehand, or if there's implications for housing benefits. So the COP3, we are now seeing some judges ask for a COP3 capacity assessment dealing specifically with the question of signing a tenancy agreement, whereas previously they did used to tend to allow you to get away with the COP3 that just deals with residence and care. When I just mentioned the new COP3 briefly in a second, you'll see that that's quite helpful. Who should sign? I'm not going to get into debate now about ICB versus local authority, but just to give you some reassurance that I had some advice in a case a number of years ago where there was an argument between the ICB and the local authority, and a barrister involved in that case was offering to me that he would sign the tenancy agreement on behalf of P, because he said there was absolutely no liability that attaches to the signatory themselves, and it's merely a mechanism for signing on behalf of P. So anyone who's acting as signatory in that way can be reassured. Ideally, perhaps family members might sign it, but again, the court seems to prefer the applicants to sign the tenancy agreements, and often will simply authorise that, even if we've asked for someone else to be authorised to sign the tenancy agreement. So I'm sorry, I'm conscious I've overrun, which I thought I would be shorter than 20 minutes. I just want to give you a reminder regarding the new COP3 form. So the new version of the COP3 was issued in July, and we've been told by the Court of Protection that soon they will not be accepting the old COP3 form. So if you've not already started using it, generally and particularly for COPDOL 11s, you do need to start using it so that when the court comes to look at the application, it's on the correct form. What the new COP3 form provides for is assessments of multiple areas of capacity on the same form. So when I mentioned about tenancy agreements, you can have residence care and tenancy agreements all dealt with on the COP3 form. It does require more information to be included on the form, such as the details of the practical steps that were taken to assist P to make their own decision, and setting out what the relevant information is for each decision that P is being asked to understand. As Amy mentioned, the reordering of the capacity assessment test is also already reflected in the new COP3 form that we have. So I have now finished. Thank you for listening, and we'll move on now to our question and answer session.
Thanks very much, Jo, and also Claire and Amy. Some really interesting topics there and lots of thought-provoking points. So we've had lots of questions coming in the chat, which is brilliant. We're going to try and pick up as many of those as we can in the next 15 minutes. The first one that I wanted to pick up on was a question about if you have a 17-year-old patient coming in, I assume, to an acute hospital for a short stay of around 5 days, would you still be applying to the courts? In our experience, the process takes weeks. So I think in typical lawyer fashion, the starting point would be to say it depends on the circumstances of the case. Generally, I would say that 5 days is a significant period of time to be depriving someone of their liberty. You may well remember the ZH case, which is from, I think, 2012, which involved a young man, I think he was about 18, 19, who was in a swimming pool when he was handcuffed by police upon their arrival, put in leg restraints and essentially put in a cage in the back of the police van for about 40 minutes. And that was deemed to constitute a deprivation of liberty. And there were damages in that case of, I think, just under £30,000, which were awarded. Now, the majority of those damages did relate to his PTSD from the experience and from it making his epilepsy worse. But I think it does highlight there the very real risks around depriving people of their liberty and not ensuring that that's a lawful process. Obviously, in that case, it was a very extreme level of restraint that he was facing. But I think even in that inpatient setting, 5 days, you are probably likely to want to seek court authorisation. Otherwise, you've got an unlawful deprivation of liberty likely on your hands. I think it's probably worth saying that if it's a planned admission, then you do have the opportunity of trying to make the application in advance. It shouldn't normally take weeks to deal with. I'd be interested in what my colleagues have in terms of experience of that. We do quite a lot of 16, 17-year-old in hospital applications to the Court of Protection, and normally they can be dealt with fairly swiftly. I think for a while we had a bit of an issue with getting the official solicitor on board to act on P's behalf, and there were some questions around them trying to get legal aid funding secured so that they can do that. But I know more recently the official solicitor has confirmed that because P is under 18, they are eligible for non-means tested legal aid. So we no longer have that delay that we used to see, which should make that process slightly quicker. I don't know if Jo, Amy or Claire, if anyone wants to add anything to that, or if you think I've covered the key points there.
Yeah, I'd definitely say so. I think practice in terms of experience varies on getting listings, but if you can engage with the official solicitor in advance and they can do what they need to do to get on board and be invited to act, then you're sort of truncating that period and you can get a hearing within the week if all is sort of running smoothly.
That's certainly my experience, and I think it's probably perhaps also worth saying that once you've made the application, you've then got that safety net that the trust has fulfilled its responsibilities. You've made your application to court, and essentially it's then in the court's hands as to how quickly they deal with it. But the fact that you've made the application in and of itself does give you a bit of a safety net. I think we will then move on to, there was a question on executive capacity, and the question was, the draft code talks about executive capacity in relation to acquired brain injury and states that if someone is repeatedly unable to put into action what they have articulated, it could be evidence that they lack capacity. And this individual has seen queries about someone who's hoarding repeatedly, being unable to put in place what's been articulated, and whether that could be seen as a lack of capacity. Amy, what are your thoughts on that one?
Yeah, a couple of thoughts which I had reading the code. So sorry, I've forgotten who it was who asked the question now. But there was mention of the code referring to the fact that the executive functioning was connected potentially to a brain injury, which again, we do see, but there are examples of impaired executive functioning connected to some other mental disorder. I think what I would probably say in relation to executive functioning generally is that it's not there to displace the assessment of someone's capacity. It's not a separate entity. There still has to be an impairment of or disturbance of the mind or brain to obviously to determine that that person actually lacks capacity. But I think what the code is getting at is if you're seeing sort of evidence of repeated unwise decision making or mismatch between what someone is saying and what they are doing, then capacity should be considered and if necessary assessed, and then you get into that 3-part test as we now have. I think the code obviously could spend a long sort of time going into executive functioning, and it doesn't, and I understand why. In relation to hoarding, I mean, obviously we had the AC and GC hoarding case from last year, and I was just reminding myself of the facts of that, and I think it was AC or GC had both a hoarding disorder, which is defined as a mental disorder, as well as obsessive compulsive disorder. So it just highlights that point that there was an underlying mental disorder there, which determined that combined with the functional element of the test meant that they lack capacity to manage their own sort of affairs. But I think there was expert evidence on capacity in that, so it clearly wasn't necessarily straight, it wasn't clear cut. But the expert in that case talked about that combination of the two, the hoarding disorder and the OCD, being almost like a perfect storm in terms of the impact it had on that person to be able to manage their affairs. So that's an area of where executive functioning clearly comes into it. There are other areas, as I say, the case study talks about impulsive eating as an example, in some of the anorexia cases as well in the court of protection. There's often reference to that executive functioning being at play. So I think the takeaway is the capacity test is what it is. Executive functioning might be overlaying that, but it just needs to be considered as part of the overall sort of capacity test, I'd say.
Lovely, thanks Amy. And yeah, I agree with all of that. We've had a couple of questions on JS, which I'm hoping Claire will be able to help us with. Probably the most straightforward one was around whether the judge directed an AMP to make an application for detention under Section 3.
Yeah, absolutely. So no, he didn't. He doesn't have the power to do that. He doesn't have the power to direct clinicians to do anything. All he can do as a COP judge is make the declaration that P is not eligible to be deprived for liberty under the Mental Capacity Act, and then kind of passes the ball back to the professionals to sort it out. He can certainly make inquiries with people, so kind of goes back to what we were talking about earlier as to available options and the limits of the court in that sense. The court is allowed to ask probing questions and invite people to provide statements and give evidence to him to answer questions that he might have, but he can't direct clinicians to do anything.
Yeah. Thanks, Claire. And there are a couple of others around detaining, so there was an elderly person been detained under the MCA, but now stable, awaiting a care home placement, so they don't need to be in hospital anymore. Would this then not be eligible for MCA authorisation, and would they need to be under the MHA as they're on a mental health ward? What are your thoughts on that one?
Yeah, it's another sort of depends answer, unfortunately. We need a bit more information about the exact circumstances. I think just as a point of principle, I would say it's less important what ward they are on, and more important to consider whether they're a mental health patient, i.e. are they receiving treatment for a mental disorder or a manifestation of their mental disorder. And it's also important to consider whether they're objecting or not as well, because if they're not objecting to being on the mental health ward, then the test for finding that they're ineligible under the Mental Capacity Act isn't satisfied, because they have to be an objecting mental health patient. So we can see situations where patients have been detained under the Mental Health Act. They stay on a psychiatric unit after the detention period has expired or the section has been rescinded. But because they lack capacity to decide to stay there, they can still have that DOL authorised under the MCA. So yeah, there's lots of different scenarios, unfortunately. But
No, that's really helpful. Thank you, Claire. I'm conscious of time, so I will move on to, there was a question we had about whether the COP-DOL 11 process is suitable for 16 and 17-year-olds who need depriving of their liberty in their own homes. So for that, I think it's the KL case, which was Bolton Council last summer, and it was Hilda who was looking at that one. In theory, if the person is in their own home, the package is not particularly restrictive and there's no anticipated change once they turn 18, you could possibly use the streamlined procedure and make a COP-DOL 11. But I would generally err on the side of caution and do a COP1 instead. I think Hilda said in that case, it's unlikely that the streamlined procedure is going to be appropriate for 16 and 17-year-olds. It's not really what it was intended for initially. I don't know if any other colleagues have anything to add on that particular one. If not, we can move on.
I think that's right. Thanks, Emma.
Yeah, I've replied to say don't use it. So I think we're seeing.
Yeah.
I think we've had one or two push back, so we wouldn't use it. The COP-DOL 11 procedure. Also, then a few people followed up with, how do you get 16 and 17-year-old community DOLS authorised? So that's something I'm afraid I just need to double check, because I know that there's the National DOLS Court, and also we have made some applications to the General Court of Protection. So if people can bear with me, I'll just clarify, and in the follow-up we'll explain in what circumstances you might use one or the other.
Yeah,
Thanks, Jo.
I think I've tended to use the Court of Protection welfare route in those ones, but that was an inpatient admission, not a community DOL. So I appreciate there might be, different considerations there.
And while Jo's looking at that, we had one about the MCA LPS consultation discuss the extension of MCA authority in relation to restriction required to enable an emergency intervention, and how might that pan out in practice. So we really don't know what's going to happen with section 4B, and it comes back to that sort of to be or not to be question about what is and is not a deprivation of liberty, particularly in the context of the Ferreira case. I think unfortunately this is one of those kind of watch this space areas, but for now what we can say is, you can treat an emergency, you can use section 4B, but only if you've made an application to the court. I think that's probably all we've got time for to go into on section 4B. And I'm just having a quick look. We've got a couple of minutes left. I'm just going to see if there's any fresh questions that have come in. I don't know if colleagues, if there's anything else they want to pick up.
While you do that, Emma, I think one of our previous webinars we talked about section 4B, didn't we?
Yes,
in
I
a bit more
definitely did.
detail. So we might be able to signpost people to that one.
Refer back to that, absolutely. Yes, sorry, just bear with us. We're just scrolling through the questions.
Yeah, there's a question from Jennifer. Are we still considering that emergency departments would not require a DOLS or COP-DOL? I mean, there isn't an exception that the Article 5 doesn't apply in an emergency department. So, and I know we're getting more and more situations where patients are stuck in an emergency department, obviously for longer than they should be in there, not receiving sort of physical health treatment. If they are, then they're being deprived of their liberty, then you would need court authorization for that. Obviously, you can put an emergency standard authorization in if they're over 18. So I think it's the emergency, again, it's not necessarily the department there that's relevant, it's what is going on, and if they're being deprived of their liberty, then that does require authorization in whichever form that's appropriate to take. Would that be your understanding, Emma, as well, in terms of the ED?
I completely agree with you, Amy, and particularly because of that concern that EDs are seeing more and more patients that are being stuck there for days. So you couldn't have a sort of blanket, oh, we don't need to do a deprivation of liberty because they're within the emergency department. It's really very much dependent on whether they are being deprived of their liberty rather than where exactly within the hospital their bed is.
Yeah, and the MHA framework may apply there depending on what they're presenting with. Obviously you've got section 136 and section 5.2 if they're appropriate, I should emphasise. But I think that probably covers that one for Jennifer.
Brilliant. I think we've managed to capture most of the questions. There's a few about the session being recorded. Yes, it is being recorded, and we will get the recording sent out to you. And I think that's probably all we've got time for now. I'm conscious we've just run over ever so slightly by 1 minute. So we will let you all go. Thank you very much for bearing with us and for joining us this morning. It's been a really interesting session, really helpful always to have your very interesting questions. So thank you so much.
Thank you very much, everybody.